I don't think that good virtual reality is fully there yet. It's going to take 5 or 10 more years of development before we get to where we all want to go. That's what Mark Zuckerberg said during a trial. Amidst the shock and awe of the controversies following ZeniMax's court case against Oculus, amidst the headlines written as if one company lost while another company won, amidst the David and Goliath size comparison of Facebook and ZeniMax juggling Oculus around like a child in a custody battle, lies an alternate view of this issue explained by Zuckerberg himself. The idea that this case evokes the struggle of an underdeveloped VR trying to reach the mainstream. In 2014, ZeniMax filed a lawsuit against Oculus alleging them guilty on 7 counts: misappropriation of trade secrets, copyright infringement, breach of a non-disclosure agreement, among other claims that all basically amount to Oculus being an unfair competitor, and they were ultimately found guilty of 4 of the 7 counts. This all began in 2012, during a period of cooperation between the two companies. Remember all that talk about Doom 3 BFG supporting VR? Wonder where all that went? It turns out that using Doom to promote the Oculus Rift without ZeniMax's permission forms the cornerstone of their claims of trademark infringement. Also, according to ZeniMax, the Rift lacked a head-mount VR software and motion sensors until Oculus's collaboration with John Carmack added those improvements after the two met up in early 2012. Carmack's contract had ZeniMax being the owner of any relevant work prepared by his employment, and the relevancy of his Oculus Rift work comes into question with this photograph included in the suit, also from early 2012. This is an unnamed id Software headset project that apparently was under development before they made contact with Oculus. According to the story told by this lawsuit, Oculus founder Palmer Luckey acknowledged in writing that ZeniMax had ownership of properties like Doom, and that their collaborative projects were to be kept under wraps. But Luckey and Carmack proceeded to demo the Rift at E3 2012, before using Doom footage to launch a Kickstarter that made $2.4 million, before getting bought out by Facebook for later revealed to be $3 billion, and coercing a group of 5id employees to follow Carmack out of their doors to seek employment at Oculus instead. Thus, Oculus had supposedly made billions of dollars by stealing millions of dollars worth of technology and staff. ZeniMax's story goes on to say that they offered a deal to share a 2% stake of Oculus in exchange to not press charges. But at this point, Oculus wasn't talking, the deal fell through, and charges were pressed. All the while Carmack was supposedly sneaking their confidential documents over to Oculus through thumb drives and wiping away the evidence. From Oculus's defense, we hear the narrative of a college-age tech prodigy slapping together working headset prototypes as early as 2010, supported, again, with photographs taken before any possible involvement with ZeniMax. According to Luckey, Carmack's contribution was a hell of a lot more minimal than the opposition claims. The NDA they had supposedly broken was never finalized, their usage of Doom footage fell under fair use, and they stayed in full and friendly contact with the company while promoting the Rift, never hearing a peep about legal issues until months later in 2014 after the Facebook purchase. But during a hearing last month in 2017, Oculus showed an email they dug up from ZeniMax chairman and CEO Robert Altman saying, VR had failed in the past, and this latest attempt is dubious as well. That would have been written in November of 2013, which would have been about 4 months before the Facebook acquisition, when apparently ZeniMax made a sharp change of mind. Oculus CEO Brendan Iribe said that the 2% stake deal was something he proposed to ZeniMax, who balked at the offer and instead proposed 15%, which Oculus wasn't interested in giving up. In protest, ZeniMax canceled their plans for VR support in Doom 3 BFG. That's where that went. Carmack called it quits when it became clear he wasn't going to get to work on VR over there, and the 5 id staffers who made the same switch were independently planning to make that move on their own. All the while, Carmack denies wiping evidence and stealing documents. That's Oculus's version of the story, and it's one that the jury has mixed feelings about. If there was any point during this whole ordeal where Palmer Luckey was most likely to just look back and say,
"I've made a huge mistake,"
then it was probably when he signed the non-disclosure agreement in 2012, because following it up by demoing the Rift at E3 was a breach that the jury punished to the tune of $200 million, the largest chunk of Oculus's $500 million penalty. But, as always, it's incredibly important to read past these headlines and see that ZeniMax was originally arguing for an amount between $2 and $4 billion in damages. They only got an eighth of their grandest of totals, and they were only able to find Oculus guilty of breaching contracts specific to the two companies, rather than pirating the technology that forms the basis of the whole VR industry. The idea of ZeniMax spinning VR as a proprietary technology is a concern Carmack expressed almost from day one. Same deal 2 years later after the trial when he posted a Facebook message detailing how ZeniMax's expert witnesses argued that Oculus's non-literal copying of their code was literal enough to count as actual copyright infringement. It wasn't enough that Oculus infringed on their Doom trademark, they also infringed on their copyrights with a few lines of code that were non-literal but similar enough. The expert witnesses were highly recognized computer science academics who were being paid to explain technological jargon to a jury of regular folk, but through a lens that favors ZeniMax's side. John Carmack wrote about this oddball spectacle moment, and so did Polygon reporter Tim Poon, who's been thoroughly covering the case for the past month. I tried reaching out to Oculus and ZeniMax reps and understandably got nothing, but Poon, on the other hand, was super down to talk.
They did a really great job in explaining how certain stuff worked, like time warping and distortion pre-computation, but they did it all through analogies. So when they finally got to explaining what a game engine was, when they were bringing up code snippets of id Tech 5, it was Sammy who offered up the idea that a game engine was like a car, and they start to refer to the id Tech 5 code base as the rage car. Yeah,
that sounds like a really flashy automobile.
Definitely, so many mega textures.
As a computer science graduate himself, Poon shared Carmack's frustration with the experts attempting to dumb down the tech jargon for the jury. Do you feel that juries of ordinary people can fairly judge matters of complicated computer science?
I believe so, and in this case, I guess they did, really. The final verdict said that they didn't find any trade secrets in the Oculus code from the ZeniMax code, but I'm not sure if that had anything to do with the ways that the expert witnesses and the attorneys were trying to educate them. It was more about some of the more straightforward answers that they got. I think that's what the defense went for towards the closing of, it was at the end of a Reeves testimony where the defense asked straightforward questions of just saying, did Oculus ever receive the source code for the ZeniMax VR testbed or Doom 3? And the answer was no, and that was pretty much as clear as it could have gotten for the jury.
So, to sum up, a few lines of code were found to be copied. The Doom and Rage trademarks were found to be infringed. ZeniMax's trade secrets, on the other hand, were found to not even be that secretive at all. And that's where the big money payout of ZeniMax's lawsuit would have been, with the techniques Carmack developed at the company to correct chromatic aberration, head and neck modeling, and drift correction. But today's competitive VR marketplace of diverse companies who had apparently all figured this stuff out on their own had convinced the jury that they weren't such trade secrets after all. A friend referred me to a similar lawsuit, Capcom versus Data East from 1994, in which the makers of Street Fighter II sued the makers of Fighter's History for basically making a fighting game. The judge ultimately ruled that Capcom was full of it because of the doctrine of savoir-faire, in which elements customary to a genre are protected from this kind of litigation. Health bars versus screens and attract modes are as integral to arcade fighting games as chromatic aberration correction, drift correction, and head and neck modeling are now ruled as integral elements of VR. So VR is free, Oculus was cleared of most damages of their charges, and ZeniMax couldn't prove their claims of trade secrets being stolen. And yet, it's hard not to get the impression that this was at least a partial victory for ZeniMax. 4 out of 7 guilty charges is a majority, sure, and $500 million is no laughing matter. In fact, it's more than the past 2 years of Oculus Rift sales combined, but Facebook makes billions in profit. And while the only people who know for sure if they'll be covering Oculus's new bills are probably Facebook themselves, we do at least have a quote from their chief operating officer saying that the lawsuit's payout is not material to their concerns. What effect do you think this outcome will have on the greater VR industry at large?
I guess it depends if people run away with the idea that this is a $500 million win for ZeniMax, or if they understand that this is about false designations and NDA breaking. Because if you look at it and just say like, oh, that's $500 million,
right?
It's because Oculus stole their stuff.
I worry about that, because when you look at a headline that just says Oculus ordered to pay $500 million to ZeniMax, it looks like a loss.
Yeah.
And then when you read the technicalities of the potential $4 billion that they were going after Oculus for, it looks more like a successful defense. They lost a bit, but not nearly as much as they could have.
Exactly. And that is kind of the problem. People look at the price tag and they will assume that, like, well, VR might be a liability at this point, because if ostensibly the first one to market did this and they were busted on this claim, then what's to say that these other companies don't have the same problems?
The biggest scare right now is the possibility of an injunction order halting sales of the Rift until they re-release it with a bit of that copyright code changed, which could very well be the non-literally copied shader code that Carmack mentions here. But what usually happens in cases of injunction is that the two companies will reach a settlement or a licensing agreement, and business goes on as usual. But outside of Oculus, existing VR developers have other headsets that they can move their software onto. The legality of working on VR hasn't really changed for other companies or the industry at large. The big thing that has, though, is the cloud hanging over Oculus and the trouble they represent to their Facebook financiers. And also, the public spectacle of seeing the sheer irony of an established multi-billion-dollar company with no history in VR suing a smaller startup for more money than 2 years of what their product is worth based on the argument that it was the smaller company who were being the unfair competitors.